We are now live at the second ITLOS Moot final. We deeply thank our judges for being here tonight and for our teams for their great effort during the competition. And without further ado, I will give the word to our president today, Judge Cabello. Please, Judge Cabello, you can start conducting this round.
Okay. Thank you very much to all of you for being here. And we are, as you know, in the final round. So we shouldn't wait anymore and start the competition. So I would like to invite the representative, the agent of the applicant, to start their presentation. You have the floor, sir.
Mr. President, Your Excellencies, members of the Tribunal. Good evening, may it please the court. My name is Michael, and along with my co-agent, Mr. Brian Edwardus, we represent the applicant, Republic of Calypso. I will be speaking for the next 19 minutes, addressing the first three submissions, which are: first, jurisdiction of the tribunal; second, the fishing activities of Azurius in the issue of Calypso are illegal and a violation of UNCLOS; and third, Azurius breached its due diligence obligation under UNCLOS. While my co-agent will be speaking for 18 minutes, addressing the last two submissions, which are: first, the conduct of illegal fishing activities in the issue of Calypso cannot be justified by a state of necessity and or climate change; and second, Azurius is responsible for the food security issues its inhabitants are facing. It indeed failed to plan well ahead on the basis of scientific evidence available, the management, preservation, and restoration of its marine environment and resources. We respectfully reserve 3 minutes for rebuttal. Moving on to the jurisdiction of the tribunal. On November 20, 2017, the respondent replied to the applicant by acknowledging the fine for the illegal activities in September 2017. However, the respondent rejected the accusations of the applicant for the events occurring in November 2017. The applicant would also like to highlight few things, which are: first, the applicant has invited the respondent for a video conference meeting on 12 December 2017. Second, both parties have conducted a total of 8 meetings during the year of 2018 and 6 meetings during 2019. And third, both parties have agreed to promptly settle the dispute through the International Tribunal for the Law of the Seas. The applicant argued that ITLOS has jurisdiction over this case under these following reasons. First, the obligation to exchange views under Article 283 of the UNCLOS has already been fulfilled during the video conference meeting that happened on 12 December 2017. Second, under Article 280 of the UNCLOS, party may choose any peaceful means of their own choice to settle the dispute. Third, under Article 287, Paragraph 1 and Paragraph 4, ITLOS is available as one of the means to be chosen by state regarding a settlement of disputes. Furthermore, in accordance with Paragraph 4, through the written agreement on 24 April 2020, the parties have chosen ITLOS and therefore must submit only to the ITLOS unless the parties agree otherwise. Fourth, under Article 21 of the Statute of ITLOS, it established ITLOS has jurisdiction over the matters arising from UNCLOS. And last, under Article 32 of the 1996 Bilateral Fishing Agreement, it is stated that disputes arising from the BFA that have failed to be settled by negotiation shall be settled before the ITLOS. It is proven that the 8 meetings in 2018 and 6 meetings in 2019, negotiated by both parties, have not settled the case, making ITLOS has jurisdiction over this case. With that being said, the applicant believes that the ITLOS indeed has jurisdiction over this case.
I'm sorry for interrupting you, Counsel. Let me ask you a question. Do you think that this tribunal composed of 3 judges has jurisdiction to hear your case?
Thank you, Your Excellency. Yes, the applicant believes the tribunal does have jurisdiction.
But the tribunal that has jurisdiction is the full tribunal with all the judges, and here only 3 judges. Do you think that only 3 judges, and what is the legal basis that you allege us to say that 3 judges can hear your case?
Thank you, Your Excellency. The applicant believes that the ITLOS has jurisdiction over this certain case as well, with only 3 judges as well. It's also because the parties have stated in agreement on 24th April 2020 to settle the dispute through ITLOS. And under Article 26 regarding the hearing, 26 of the ITLOS statute, the hearing shall be under the control of the president, or if he is unable to preside, of the vice president. If neither is able to preside, the senior judge present of the tribunal shall preside.
Yes, Counsel, but in this agreement, it establishes that 3 judges can hear the case?
No, Your Excellency. There is no clear, it isn't clearly stated in the agreement.
Okay, thank you. You may proceed.
Thank you, Your Excellency. Moving on to the first submission, the fishing activities of Azurius in the EEZ of Calypso are illegal and a violation of UNCLOS. The applicant would first like to point out that as both the applicant and the respondent had already implemented the IPOA-IU in its respective domestic regulation, the definition of IU fishing itself can be taken from the IPOA-IU, and in this case, the conduct by the Azurian vessels, which occurred on February, August, September, and November, falls within the scope of definition. With that being said, it can be stated that Azurius had violated its obligation, which is embodied in UNCLOS. First and foremost, Azurius had violated the sovereign rights of the applicant under UNCLOS. As stated in Article 56, Paragraph 1A, the coastal state in EEZ has a sovereign right in conserving and managing the natural resources. And in Paragraph 1B, one of the coastal state jurisdiction in the EEZ includes protection and preservation of the marine environment, which is also an obligation according to Article 192 of UNCLOS for all states. Furthermore, in the MV Virginia case, the tribunal emphasizes that in exercising its sovereign rights in the EEZ, the coastal state is entitled to adopt laws and regulations establishing the terms and conditions for access by foreign fishing vessels to its EEZ. In accordance with this, the applicant had established these rights through the bilateral fishing agreement between the applicant and the respondent, and also into its domestic legal instrument, which are the Criminal Code and Marine Conservation Act, and enforce it in the conduct that had already occurred in September and November. Furthermore, Azurius had failed to fulfill its obligation in Article 58, Paragraph 3 and Article 62, Paragraph 4, which clearly conveyed that all states must comply with the laws and regulations adopted by coastal state. In the MV Saiga case, number 2, the tribunal stated that under the provision of Article 58, Paragraph 3, the rights and obligation of coastal and the state under the convention arise not just from the provisions of the convention, but also from national laws and regulations adopted by the coastal state in accordance with the provisions of this convention. The respondent has failed to comply with the applicant's domestic regulation, such as the Criminal Code Article L92, Paragraph 3, regarding the sanction for IUU fishing, and the Marine Conservation Act, Article 86, Paragraph 2, regarding the establishment of Calypso's marine protected area. And the
I'm
obligation
sorry
of
to interrupt you, Counsel. You
Yes,
mentioned
Excellency.
this Saiga case. Are we bound to follow the precedent and the definition that you just invoked here in the Saiga case? Are we bound, or are you using this as an obligatory source of international law?
Yes, Your Excellency, thank you. The point that is being made by the applicant by referring to the MV Saiga case is to give an enlightenment and interpretation of the certain articles of UNCLOS, which is in this case the Article 58, Paragraph 3, to further establish more about the rights of coastal state to adopt its domestic laws in the EEZ. May I continue, Your Excellency?
Yes, please.
Thank you, Your Excellency. There are several breaches of obligations that can be highlighted. For example, on 6 November 2017, the vessels did not have any fishing logbooks, and the species targeted nor the location of the fishing activities were not matching with the actual species fish, and the location of these fishing activities. Therefore, through this one example, Azurius have breached the obligation stated in Article 6 of the bilateral fishing agreement. The applicant would like to cite from the Hoshimaru case, where the tribunal is of the view that a violation of the rules on reporting may be sanctioned. The tribunal also states that monitoring of catches, which requires accurate reporting, is one of the most essential means of managing marine living resources, and it is the right of a state to apply and implement such measures. Therefore, through this one example, we can see how Azurius had clearly violated the law and once again failed to do its obligation, which is to pay the fine resulting from the violation. In addition, Azurius refused to pay the fine because it argued that the crew members who conducted fishing activities were simply following fishery stocks, which have moved away from the area of Vonikulu because of climate change. Therefore, Azurius acknowledged that there is indeed the intention for this vessel to conduct fishing activities. And this means...
I'm sorry to interrupt you. I'm sorry.
Yes, Your Excellency.
May I ask you a question?
Yes, Your Excellency.
Do you think that that it's necessary to make returning to something that you already said before? It's necessary in exchange of view. You mentioned that there were meetings between the parties before you brought the case to the attention of the court. But is it necessary to have this exchange of views when you already mentioned that there was an agreement of the two parties to bring the case to ITLOS?
Yes, the applicants believe that this is necessary because it is in accordance with UNCLOS, and the tribunal can be stated as a last resort, the applicant believes. May I continue, Your Excellency? Thank you.
Yes.
Furthermore, the conduct that occurred in November also violates the sovereign rights of the applicant as stated in Article 61, Paragraph 1 of UNCLOS, to set the allowable catch in the EEZ. The catch of 12 devil rays is illegal due to its potential extinction, and also the size convention. As party to the size convention, the applicant has the right to apply sanction or fine in accordance with Article 8, Paragraph 1A, which enables a state to apply sanction. The applicant strongly believes that this is one of the necessary measures to ensure the preservation of devil rays from possible extinction, which is indeed...
Sorry to interrupt you again, excuse me.
Yes, Your Excellency.
You are mentioning that the respondent violated the decision that was taken by the coastal state to limit the total available catch to a certain amount of kilos or tons of fishing. However,
yes.
What did your country consider the situation of the other side of this conflict, in the sense that they are passing through a situation of a big food crisis? So they are in need really of catching more fish, eating more fish. Otherwise, they will have a terrible hunger problem. And under the convention, as you well know, it has to be considered also the needs of this of all the countries that are exercising their right to fish in the economic zone when there is an agreement, like in this case, or in the high seas. So what can you answer to that? Because you are not mentioning this situation. This is a particular fact that has to be considered in every case. Thank you.
Thank you, Your Excellency. My co-counsel will further elaborate. That is regarding the Article 25 of the RCWA. But my response to this is such conduct cannot also impair or damage the essential interest of our state, because the devil rays is one of the when regarding the conservation of the marine living resources, you have to see it as an ecosystem. So because the devil rays is protected due to its potential extinction, therefore we must act as we must act in accordance with the best interest of the species. Therefore, the respondent must also pay attention to this because of the species extinction damage, Your Excellency.
Thank you, Counsel. You mentioned the CITES Convention. Do this tribunal has jurisdiction to decide and rule upon the CITES Convention?
Thank you, Your Excellency. No, but it is ratified by both parties, and according to Article 293 of the UNCLOS, the tribunal must therefore consider it. May I proceed, Your Excellency?
So, in which capacity are you invoking CITES, as an applicable rule or as an interpretation of the convention?
An applicable rule, because it is also one of the means to exercise the sovereign rights of the applicant, which is the conservation and preservation of the marine living resources.
Do you have any case in which this court applied another convention, especially an environmental convention?
No, Your Excellency, we do not have.
So perhaps the conclusion is that you cannot invoke the CITES Convention as applicable rule, right?
No, because the applicant believes that this is still applicable according to Article 293 of UNCLOS, Your Excellency.
Okay, you may proceed.
Thank you, Your Excellency. Moving on to the next submission, Azurius breached its due diligence obligation. The applicant would first like to cite from ITLOS case number 21, where the tribunal stated that in the case of IU fishing in the EEZ, the obligation that must be ensured and fulfilled by the flag state is an obligation of conduct, which is a due diligence obligation. In addition, as stated in the South China Sea Award, the PCA agreed with the tribunal statement in the advisory opinion that in the context of duties of a flag state with respect to fishing by its national, the obligation stated in Article 58 paragraph 3 and Article 62 paragraph 4 extends to a duty to take the necessary measures to ensure that their nationals and vessels flying their flag are not engaged in IU fishing activities.
I'm sorry, Counsel. In what capacity are you invoking a rule of an arbitral tribunal before this permanent tribunal will have its own case law?
Thank you, Your Excellency. The applicant only referred to the PCA tribunal as an interpretation as well.
Only as an interpretation of what, Counsel?
Of duties of flag state in the coastal states EEZ, Your Excellency.
Thank you, Counsel.
Thank you, Your Excellency. Regarding the measures by the respondent to ensure the compliance of its national as its due diligence, the applicant believed that the respondent had failed to do so. This can be supported by the facts from each of the conduct that had already occurred. For example, on the events that occurred on the 30th of September 2017, the Azurian vessels that were seized did not have any fishing logbooks or any adequate fishing authorization on board, which is regulated in Article 6 of the BFA as one of the requirements to be fulfilled by a vessel that wishes to conduct activities in the EEZ. In addition, the respondent had also failed to ensure the compliance of its vessel by failing to enforce its criminal code, which is an obligation stated in Article 94, paragraph 1 and 2 of UNCLOS. Given the light of the conduct that had already occurred, the respondent was supposed to enforce its criminal code to give a deterrent effect as a way to ensure the compliance of its national. This is in accordance with the tribunal statement in the advisory opinion, case number 21, in paragraph 137 and 138. However, the respondent did not enforce it, thus making the conduct of IU fishing in the applicant's EEZ to go on again several times. With the arguments aforementioned before, the applicant asked the tribunal to declare that first, the fishing activities of Azurius in the EEZ of Calypso are illegal and a violation of UNCLOS. And second, Azurius breached its due diligence obligation under UNCLOS. With that being said, that concludes my first two submissions regarding the merits of the case. The pleading will continue with my co-agent, Mr. Reza Maulana. Thank you, Your Excellency.
Just to tell you the time, you have just finished 19 minutes.
Thank you, Your Excellency.
I would like to invite now then to the second agent of the applicant to take the floor now. You are invited to participate now then.
Thank you. Mr. Madam President, Your Excellency, members of the Tribunal, distinguished agent of the respondent, good day. May it please the court. My name is Reza Maulana. As the co-agent of the applicant, Republic of Calypso, I will be speaking for the next 18 minutes, addressing the last two submissions, which are first, the conduct of illegal activities in the EEZ of Calypso cannot be justified by a state of necessity and or climate change. But second, Azureus is responsible for the food security issues its habitant are facing. Thus, it indeed failed to plan ahead on the basis of best scientific evidence available, the management, preservation, and protection of the environment. Your Excellency, before moving to our submission, the applicant would like to point out an issue concerning the admission of guilt. Your Excellency, it is needed to be established in the court that activities on September 2017 and November 2017 are similar and alike. On September, there was a malnutrition issue known from the case. Next, in November 2017, there was a food shortage. Both of these defenses are used by the respondent as a grounds to justify their actions. This claim is based on the fish stock migration warned by the Pacific Ocean Advisory Body and the Curious 16 pandemic that the UNGA and the FAO declared. These two reasons are gradually happened since 2016 until the time frame that this stellar case occurred. However, what the applicant would like to point out is that the respondent admit the guilt on September by paying the fine imposed by the applicant. But later on, the respondent used the defense of state of necessity for the November 2017 event, which apparently have a similar condition. This is very contradictory with one another. This conduct is unacceptable.
I'm sorry to interrupt you, Consul. I have two questions, but the first question is, do you have any other example of case law where paying a fine is corresponding to admission?
Yes, Your Excellency. However, the point that the applicant would like to make is that the doctrine
Which case, Consul?
The respondent would like to introduce the doctrine of Estoppel, in which the elements of Estoppel in the MV North Star Tribunal is declared in paragraph 307 are representation by conduct, word, or silence. In this case, the applicant believes that Azureus has fulfilled the element of conduct when the Azureus pay to the applicant, and then Azureus reply the applicant message on 20th of November 2017 by paying the fine of 12,000 euro. On the second element, the element of evidence of representation. In this case, the evidence of the representation are the fact that respondent paid for the fine imposed by the applicant. The principle of Estoppel is a general principle of law, which is a source of international law under the Article 38 of ICJ Statute, thus may be applicable in this case. In the MV North Star case, Panama v. Italy, the tribunal stated a situation of estoppel exists when a state by its conduct has created the appearance or a particular situation and another state, relying on such good conduct in good faith, has acted and abstained from an action to its detriment. The effect of the notion of estoppel is that the state is precluded by its conduct from asserting that it did not agree and recognize a certain situation.
I'm sorry, Counsel. The doctrine of estoppel only exists in common law countries, so it's hardly considered a general principle of law by civil law countries. How do you respond to that provocation?
Thank you, Your Excellency. However, the applicant believes that this doctrine is a general principle of law as it has been implemented in civilized country, even though it is mainly sourced from the common law system. But as we all know, that the tribunal here stands in public international matters. Thus, this applies the general principle of law.
Are you suggesting that common law countries are more civilized than others, Consul?
With all due respect, no, Your Excellency, but civilized country here has a historical background, as previously it was used by the Europe to define the barbarians that they are not civilized. In this case, most of the countries now and most of the states are already classified in this general principle of law as a civilized country. If I may proceed, Your Excellency.
Yes, you may, Consul. Thank you very much.
In conclusion, the respondent shall not plead for state of necessity. They admit guilt for the September 2017 by pleading malnutrition. This has the same ground on the state of necessity arguments they bring for November 2017, which is the shortage of food caused by the same Curious 16. Thus, the court shall stop the respondent claim on the state of necessity. But even if the respondent still brings the arguments of state of necessity, the applicant will respond with our third submissions. The applicant would like to point out that the conduct of illegal fishing activities in EEZ of Calypso was not justifiable under a state of necessity nor climate change. This submission will be divided into two parts. First, I'm going to elucidate why this couldn't be justified as a state of necessity, then relating the illegal fishing activity to climate change. Based on Article 25 of the International Law Commission's article on state responsibility, in order to justify an illegal fishing activities by a state of necessity, it needs to be the only possible way for a state to safeguard the essential interest against three things. First,
sorry for interrupting you, Counsel. I must have to ask you this. In what capacity are you invoking the draft articles of the International Law Commission?
The draft of International Law Commission are interpreted here as a source of international law, as this is mostly a customary international law, and this has been widely accepted, and opinio juris, which fulfill the element of customary international law. Your Excellency.
Do you have examples of opinio juris confirming that the circumstances precluding wrongfulness are corresponding to customary international law, Counsel?
With all due respect, Your Excellency, we would like to refer to the case of Gabčíkovo and Nagimaro's case, where they invoke these kinds of doctrine, and the tribunal stated that it must constitute an extreme and actual threat of peril. Thus, we believe that the Gabčíkovo-Nagimaro's case also recognized the doctrine of state of the doctrine of state of necessity interpretation of the RCWA 25 as one of the source of international law. If Your Excellency may let me proceed.
Actually, in that case, the article was not applied, was just referred to. And you are asking us not to apply it here, saying that it corresponds to the law. I would like you to prove that the article corresponds to the law. Do you have any precedent from this court, not the court from The Hague?
Your Excellency, as we all know, the state of necessity have a high threshold to prove. Thus, as far as the applicant knows, this court, the ITLOS, has rarely used the doctrine of state of necessity due to the high threshold it was being.
And this court has ever applied the draft articles in any case or any recent case?
In certain cases, the applicant believes that the ITLOS tribunal, none that the applicant would like to bring in this case, any cases from the ITLOS tribunal implemented this article of RCWA.
So you are saying that you are invoking a law that we never applied?
We believe that the tribunal has applied this this law in certain cases, but apparently the respondent is the one who brings the claim of state of necessity in the submission to this court. Thus, the applicant feels like the need to respond to the state of necessity here, Your Excellency.
That makes sense. You take too long to answer this, but can you give me one case in which this court dealt with the draft articles on state responsibility?
With all due respect, the applicant hasn't found the related cases applying the state of necessity from the ITLOS case.
Thank you, Counsel. You may proceed.
In the several minutes, the applicant will prove that Azurius' illegal fishing activities couldn't be justified by state of necessity based on the following facts and arguments. Firstly, the condition in Azurius does not indicate a grave and imminent peril. A state can invoke a state of necessity if its essential interest is threatened by the grave and imminent danger. The ILC highlighted that the peril must be extremely serious and a threat at the actual time. The danger has to be objectively established and not merely apprehended as possible. According to Gabčíkovo-Nagimaro's case, the danger must constitute as an extreme and actual threat of peril with a high standard of proof to establish necessity. Both parties in this case, Hungary and Slovakia, have placed on a record an impressive amount of scientific material aimed to reinforcing their respective arguments, but the grave and imminent peril wasn't met, as Your Excellency stated that the claim was rejected. In this case, Azurius' claim has not met the high standard of proof in the ICJ. The documentary release on the website of BBC and a statement from a former guide on the northern beaches are not enough to prove the existence of a serious peril. The occurrence of malnutrition issues suffered in the northern part of the island is also not a strong argument to categorize this as a grave and imminent peril because it is not impacting the whole Azurius. The warning in 2012 by the Pacific Ocean Advisory Body, independent expert, and articles from the Nature about the impact of climate change on its fishery stock and the potential relocation beyond its EEZ. Respondents should have started to consider the possibility that fish migration due to climate change would occur in 2015. From the fact above, we can draw a conclusion that the respondent does not prepare themselves for a predictable condition that will possibly occur in the future. But secondly, it was not the only way to face the food crisis. Article 25 of the ILC stated that the measure must be the only way available to safeguard that interest. The plea is excluded if there are other lawful means, even if they are much more costly or less convenient. The illegal fishing actions done by Azurius could be justified if it is only the only means in facing food crisis. Azurius should be able to use other methods in dealing with the food crisis. Your Excellency, if I may enlighten the court, in Fuji back then, when the COVID-19 appears, Fuji as a small island developing state facing a danger, and they introduced a home gardening initiative. Other possible options were not tried by Azurius before committing the act of illegal fishing. It is also explained in the commentary of Article 25.15 that the only way is not limited to unilateral actions and solution, but also to cooperation with international organizations. According to the Stellar case, Azurius had not done any sort of cooperation with other states, international organizations, or Calypso, even though Calypso as the applicant have an excellent relationship with Azurius since their respective ratification of UNCLOS. Thus, it shouldn't be a big problem for Azurius to ask Calypso for help in dealing the food crisis. But lastly, Your Excellency, the legal fishing activities have impaired an essential interest of Calypso. Your Excellency, Cabello, if this may enlighten your question previously with my co-agent, a wrongful act to protect state essential interests, even under state of necessity, must never damage an essential interest of the other state or the international community. It is defined in the Gabčíkovo Nagimaros that the ecological balance is an essential interest for all states, and the illegal fishing activities done by Azurius had violated the essential interest. The fishing of 12 devil rays on 6th of November 2017 is not about the quantity, but it's all about the quality, Your Excellency. As an endangered species state under the CITES Convention, taking 12 species will damage the ecosystem and the balance of the nature. If the respondent would like to argue for the right of food, then the vessel would not have to go that far to the Gold Seahorse. They could just fish right there and get the amount of quantity, even more than 12 devil ray species. But lastly, Your Excellency, Azurius contributed to the food security issue in this case. In the subparagraph of 2b, Article 25 of ILC, it established that necessity cannot be invoked if the responsible state has contributed to the situation of necessity. For the plea of necessity to be precluded, the contribution must be sufficiently.
I'm sorry for interrupt you, Counsel. Before you move on, you are invoking Gabčíkovo Nagimaros, the concerns about the environment, in order to justify the not application of the circumstances precluding wrongful act, but you are saying that the climate change cannot constitute. Isn't paradoxical that you are using the environment as an argument, since you do not accept the environment as a circumstance precluding a wrongful act?
Your Excellency, if the applicant would like to beg to differ, it is not the applicant who stated about the climate change. It is the premise from the respondent that stated the climate change. The applicant believed that the condition of fish migration is not even a climate change because it is first predictable, but secondly, mahi-mahi and red snappers were put under the UN fish stock migration and listed as highly migratory species. Thus, it is not the condition of climate change that the applicant would like to defend in this case.
What is your scientific source in order to say that it's predictable?
The scientific source to say that it is predictable is the Pacific Ocean Advisory Body, which already stated from 2015, the Pacific Ocean Advisory Body are considered as a best scientific evidence as it deals with the research of the marine environment, and it is not non-political, and it is not affiliated to the applicant, not the respondent. Thus, we believe that it is the best scientific effort to establish that it is not climate change.
Can this court disagree and adopt a precautionary approach?
Your Excellency, in order to uphold the precautionary principle, the applicant still believe that the respondent has not fulfilled the threshold to adopt the same principle as the respondent itself have 20 years of overexploitation previously, Your Excellency. Thus, if the precautionary principle would like to apply, then the respondent would like to be liable from 20 years previously due to the overfishing exploitation. If Your Excellency, let me proceed.
Yes, you can proceed.
Thank you, Your Excellency. Lastly, Azurius contributed to the food and security issues. Azurius indirectly contribute to the crisis as it failed to ensure the proper conservation measures to protect their fishery stocks caused by the fish migration from Honikulu to Gold Seahorse. Therefore, the illegal fishing activities couldn't be justifiable by a state of necessity. The Illegal Fishing Act could not be justified by a climate change either, because Azurius does not provide a strong scientific evidence. It is different from the Gapchikovo v. Nagimarus, where they provide an ecological proof that if the dams were contaminated, then there will be drought there. There will be pollution, pollutable of the water in condition. They have a certain high threshold, but in this case, the Azurius did not. Lastly, moving on to our last submission, it is our submission that the respondent is entirely responsible for the food security issues caused by the failure on planning ahead according to a scientific evidence, management, and preservation of its marine environment and resource. As stated on Article 61, Paragraph 2 of UNCLOS, the food insecurity issue Azurius faced was their responsibility because of several reasons. Firstly, Azurius failed to cooperate before executing an illegal fishing act as a failure of management. Article 63, Paragraph 1 of UNCLOS stated that the obligation for state with the same stock in their EEZ to conserve and manage the stock either directly or through appropriate sub-regional or regional organization. Azurius did none of this action in order to face the food security there. Azurius also failed to plan ahead, as they all know that 20 years of harmful fishing practice led to overexploitation, and they only enact the Marine Conservation Act on 2014, whereby the bilateral fishing agreement was introduced back in 1996.
I'm sorry, Council, you have only 2 minutes, but could you explain to us why it isn't apply the principle of basic circumstances of humanity in this situation of grave hunger and the situation as that the pandemic create?
Your Excellency, in regards to the situation of the pandemic happened on 2016, while the fishing activities on 2017. Therefore, it is not imminent, and it is within a long period of time. Thus, the applicant believed that Azurius may have contributed much more in the time frame of 1 year, but they failed to do so. Therefore, we can conclude that the respondent Azurius, in this case, is completely responsible for the food security issue they face because of failure to planning ahead its marine protection. Mr. and Madam President, Your Excellency, members of the Tribunal, the respondent respectfully requests the Tribunal to adjudge and declare that first, the fishing activities of Azurius in the EEZ of Calypso are illegal and in violation of UNCLOS. But second, Azurius breached its due diligence obligation under the UNCLOS. Third, the conduct of illegal fishing activities in the EEZ of Calypso cannot be justifiable by a state of necessity nor climate change. But lastly, Azurius is responsible for the food security issues inhabitants are facing. It indeed failed to plan ahead on the basis of best scientific evidence available, the management of preservation and restoration of its marine environment and resources. With the foregoing arguments, the applicants conclude our submission relating to the merits of this tribunal. Mr. and Madam President, thank you for your attention. May it please the court.
Thank you very much. Now I would like to invite the representative of the respondent, the first counsel can now intervene. So I give you the floor. Sir.
Thank you, President Cabello. Honorable members of the International Tribunal for the Law of the Sea, opposing counsels, Registrar Madam Weston, and everyone else who is watching this pleading today. Good evening from where I stand. My name is Eduardo Cavalcante, and now I will be respondents counsel addressing the first two requests, for which we will use 22 minutes of our time. Whereas my co-counsel, Kelson, will address the last two requests and use 15 minutes of our time. remaining 3 minutes for rebuttal. Members of this tribunal, I would like to start with a very famous advisory opinion of the International Court of Justice. In 1996, when this tribunal was founded, the International Court of Justice, upon the request of the UN General Assembly, decided, and I quote, "In view of the current state of international law and of the elements of fact at its disposal, the court cannot conclude definitively whether the threat or use of nuclear weapons would be lawful or unlawful in an extreme circumstance of self-defense in which the very survival of a state would be at stake." President Cabello, we're not here before a case in which we discuss the use of nuclear weapons, fortunately, but we are indeed discussing the very survival of a state. Having said this, first, I'll address some objections on the jurisdiction of this tribunal. Second, I will expose some facts that help respondent construe its case. And third, we will start with our arguments on the merits. Our contentions to first are, first, a jury is not liable for the violation of an obligation to ensure that vessels flying its flag do not conduct IU fishing in a foreign EEZ. Second, Calypso does not have any proof of illegal fishing activities conducted by the Azorean fishing vessels in its EEZ in February and August 2017. Moreover, the fishing activities in October 2017 fully respected the total allowable catch limits of the 1996 bilateral fishing agreement, hereinafter referred to as BFA. These are our contentions. Going to objection jurisdiction. May please the court open the case file on Article 32 of the BFA. I quote, "Any dispute concerning the interpretation or application arising out of this agreement, which it has not been possible to settle by negotiation, shall be settled on the basis of the procedure provided in Part 11 of the UNCLOS before the International Tribunal for the Law of the Sea."
I'm sorry for interrupting you, counsel. Could you give this tribunal the definition of dispute?
Dispute, according to the Mavromatis case of the Permanent Court of International Justice, actually the most referenced authority on the definition of dispute, it's when the parties have opposite desires and the parties have made it clear to each other. The other one has resisted that pretension under international law.
And is it applicable here, this old concept?
Yes, thank you for your question, Your Honors. It is indeed applicable. If we consider the persuasive effect that it has, since it has been quoted in a wide variety of cases, not only by the International Court of Justice, the successor of the PCIJ, but also by this tribunal in several instances. So many instances that it would be actually not feasible for me to mention them all here. If you notice, members of this tribunal, Part 11 concerns activities in the area. More specifically, it's Section 5. Therefore, this clause should not be considered. Actually, this is the reason why the parties to this dispute, they agreed on a special agreement, a compromise, to bring the case to this tribunal on the 20th of April 2020. We do not even need to see the content of this special agreement because the applicant's claims, they actually do not contain any reference whatsoever to the BFA. It only alleges the violation of UNCLOS, not of the BFA. And therefore, this tribunal does not have the jurisdiction to rule on the violation or not of the BFA provisions. If I may proceed.
I'm sorry, Consul. Since you are contesting the jurisdiction of this tribunal, do you believe that a tribunal composed by only 3 judges can hear this case?
I do believe, sir, and I thank you for your question. One of the qualities of the International Tribunal for the Law of the Sea that distinguishes it, for example, from other permanent courts such as the International Court of Justice, is its capabilities upon the will of the parties. The parties should accept this special chamber established to hear specifically that dispute. If the parties so will, the tribunal will elect 3 judges to hear the case, and the parties should accept or request another selection of judges.
And what is the legal basis for this affirmation, Consul?
This is actually in the statute of this tribunal. I hope I'm not wrong, but it's somewhere between Articles 15 and 17, I guess. I'm
It's
sorry.
Article 15. Thank
sorry.
you. You may proceed.
Thank you. Now, some exposition of facts. Members of this tribunal. Claimant, the advocate in this case, omitted very important facts, and Judge President Cabello highlighted this. Azores is a small island developing state of less than 33,000 inhabitants. In the year 2015, the year before the Curious 16 outbreak, the tourism sector accounted for 58% of its gross domestic product. Other 25% were from American and European investors dedicated to Azorean marine protected areas. There is not much left out of that. And it's also a proof that Calypso has done much for its marine environment. Also, it is a small island developing state. It faces the common hardships of such a very specific and fragile and vulnerable kind of nation. The specific circumstances, 60% of the food consumed in Azores prior to the Curious 16 outbreak was imported. This heavy dependence on external markets, the great costs for transportation and infrastructure, the vulnerability to climate change are issues that must be considered. With the Curious 16 outbreak, in July 2016, the president of Azores declared that the tourism sector, which I remind you is responsible for 58 of the Azorean GDP, completely collapsed. International trade froze, which means once again that its heavy dependence on external markets became a great burden for the Azorean people. This, as was mentioned by
Excuse me, I would like to interrupt you. Excuse me. You are mentioning humanitarian and considerations related with human rights. Do you consider that it is within the jurisdiction of this tribunal to make a decision on this kind of issues? Is there any recent case in which the ITLOS has to take a position on this question of humanitarian and human rights? Please, if you can answer that.
Thank you, President Cabello. Indeed, this tribunal has been very careful not to emit judgments outside the scope of its material jurisdiction, and therefore it has used the term considerations of humanity. The 2 main cases that used that term were the MV Saiga in the merits and also the Virginia G case. In this case, we propose that Article 194 as applicable law should be considered as it enshrines the principle of common but differentiated responsibility, but together with considerations of humanity, Azorean obligations have to be considered under this perspective. Now, these are the facts. Regarding our first request,
You haven't responded to the president. The president asked about the recent cases, and the Saiga and Virginia are not so recent, right?
Yes, they are not so recent. Virginia G, it's more than 5 years ago. However, they were the cases on the merits that made those considerations of humanity so famous. However, it has been applied also in, for example, provisional measures procedure.
Thank you. You may proceed.
Continuing, our first request is that actually there is no such an obligation of the flag state to ensure that vessels flying its flag are not engaged in IUU fishing. Basically, this tribunal, in its advisory opinion 2015, observed that under Articles 58, paragraph 3, 62, paragraph 4, and 192 of the UN Convention on the Law of the Sea, there is somehow, individually or together, it's not clear from the outset, such an obligation of due diligence to ensure that vessels flying the flag state's flag.
Sorry to interrupt you again. Excuse me. You are mentioning Article 58, paragraph 3. In that paragraph, it is the convention is stating the states shall have due regard to the rights and duties of the coastal state. How do you intend that expression, due regard? What does it mean?
President Cabello, thank you for your question. The due regard is that in exercising their rights and duties on other countries' EEZ, they must have due regard. They must consider the other states' rights and also interests, for example, under Article 87 of the UN Convention on the Law of the Sea. But irrespective of this perspective, we contend that Article 58, paragraph 3 is not applicable in the present case. Professor Alexander Preuls from the University of Hamburg, he highlights that a condition must be fulfilled for Article 58, paragraph 3 to be applicable, to be pertinent. And I would like to quote the article itself. In exercising their rights and performing their duties under this convention in the exclusive economic zone, states shall. If you realize the rights and duties regarding fishing of Azorius are not within this convention specifically, but within the BFA, which is not within this tribunal's material jurisdiction. For example,
I'm sorry for interrupting you, Counsel. In what capacity are you invoking the quotation of Alexander Preuls?
Alexander Preuls is a renowned professor of international law and international law of the sea, and it's well known that the most renowned publicist's opinion must be considered as subsidiary source of international law.
So we are not bound to follow what he says?
Indeed, you are not.
And have this court ever quoted a scholar before?
I apologize for I don't recall right now.
Thank you. You may proceed, Counsel.
Thank you, Mr. Lima, Your Honors. So Article 58, paragraph 3 is not applicable in this case. Also, Article 62, paragraph 4 merely contains the coastal state's prescriptive jurisdiction. This is actually the opinion of Myron Nordquist, Shabtai Hosen, and Louison in the authoritative Virginia commentary, which I quote, paragraph 4 establishes and illustrates the competence of the coastal state to regulate foreign fishing in its exclusive economic zone. In
I would like to pose a question that before we go on with the argument. On what basis and on what part of the convention do you find the basis to come to this tribunal, the jurisdiction of this tribunal? What part of the convention is the support for this argument? Why are you, under which part of the convention are you coming to this tribunal?
Oh,
to
thank you.
invoking the jurisdiction of this tribunal?
Thank you, Your Honor. This jurisdiction tribunal can be observed from Article 288 in Part 15, Paragraph 2, and also in Article 21 of the ITLOS Statute, which is the 6th annex to the convention.
So why did you mention Part 11 then? This is something that confused me very much, because Part 11, in what sense do you find Part 11 is applicable to this case?
This is indeed respondent's contention. Part 11 is not relevant to this case, and therefore this tribunal.
Why did you mention Part 11 then?
Because opposing counsel mentioned Article 32 of the BFA Convention to establish the jurisdiction of this tribunal over the BFA.
Well, I mean, but you don't have to follow what the applicant is saying. I mean, it was a little confusing, really.
I understand. I do not agree with him. I object by saying that because it refers to Part 11, this tribunal does not have jurisdiction to decide on the BFA.
Case completely. There's no application of Part 11 to this case.
Indeed, I agree with Your Honor.
Okay, fine.
Thank you, Madam Judge. And this opinion of the Virginia commentary is shared, for example, by Judge Pike in his separate opinion in the 2015 IAU Fishing Advisor opinion, and by also renowned publicists such as Valentin Schatz and Jian Gao. Finally, Article 192, as general as it is, could not be read as containing such an obligation that is specific as to ensure that vessels flying Azurean flag should not be engaged in IUU fishing. A systematic
I'm sorry, Counsel. There is something that causing me some a little bit of disturbance. You invoked 3 scholars and a dissenting judge to reinforce your claim. Don't you have the law or perhaps a judgment that reinforce your claim? In what capacity are you bringing all these subsidiary sources?
As I have mentioned earlier, Mr. Your Honor's Judge Lima, it's in the capacity of interpretation of persuasion.
Okay, you may proceed if you think it's useful.
And Article 31 of the Vienna Convention on the Law of Treaties contains the interpretation is also not only based on ordinary meaning, but also on the context, provided that the context clearly indicates that Article 192 cannot impose such an obligation to ensure that vessels flying the flag state's flag should not be engaged in IUU fishing. No article, no provision, the UN Convention on the Law of the Sea per se imposes such an obligation on the flag state. Therefore, if there is no further question on this first argument, I'd like to proceed to my second one. Thank you. Well, if this tribunal finds that there is actually such an obligation of due diligence, Azures has complied with its due diligence obligation to ensure that vessels flying its flag do not conduct IUU fishing. Here, we need to understand that—
I'm sorry, you just mentioned that if we find that there is an obligation, you start saying that we already recognize this obligation in an advisory opinion. Am I wrong?
Your Honor, no, you're not wrong, but we are proposing an overruling.
Okay.
This tribunal has said that one case is not enough to configure IUU fishing responsibility on the flag state. It's an obligation of conduct. However, we must understand here the cooperation framework established between the parties. Azures is not expected, and now the BFA is applicable law under Article 293. Azures is not expected to enforce Calypso's law in Calypso's EEZ. Under the cooperation framework, for example, the vessel compliance clauses in Article 6 of the BFA, Azures must, for example, receive and check the legality of the notifications upon entrance, exit, and permanence every 2 hours in the EEZ. Azures has done it all. It did not investigate the issues in February and September because they simply did not concern fishing. They concerned navigation. Considering this cooperation framework established between the parties and the rule regarding the common but differentiated responsibility in Article 194, it is clear from the outset that Azure has not violated such an obligation. I see that my time is running out, and I believe that because many questions were asked, I would like 1 more minute to conclude my points. So, President Cabello. Okay, so finally, Respondent's second contention. Thank you. Finally, Respondent's second contention is Calypso does not have any proof of illegal fishing activities conducted by the Azurean fishing vessels in its EEZ in February and August. Moreover, the fishing activities conducted in October 2017 fully respected the total allowable catches of the 1996 BFA. Members of this tribunal, the Big Eyes on You service only spots the presence of the vessel, not the fishing itself. So there is no IU fishing there. And the total allowable catch limit, it should be considered on the fishing authorizations that were issued, not on the actual fishing that happened. And considering so, there is no claim from the applicant that the fishing authorizations issued by Azurius were contrary to the total allowable catch limit established by the parties. Finally, as this is a single claim, a single argument, my co-counsel Kelson will request for relief, including all the requests. Thank you. If you have no further questions.
Thank you very much. I now call the representative of the respondent, the second agent, to take the floor. You have the floor, sir.
Thank you, Mr. President. And honorable members of this tribunal, opposing counsels, good evening from where I'm sitting. My name is Kelson Pacifico, and I will continue the representation of the respondent addressing the merits of this dispute. As the first two claims had been well discussed by my co-counsel, I shall expose the facts that lead to our two further submissions. Firstly, I may refute some main arguments of my opposing counsel. Firstly, the opposing counsel has said that the payment of the fine...
I'm sorry to interrupt you, counsel. Your co-agent called you co-agent, and you are calling yourself counsel. What is the difference between counsel and agent?
I am sorry, Mr. Judge Lima. I am the co-counsel in this capacity.
And what is the difference between an agent and a counsel, according to the statute of the tribunal?
If I may have a minute.
No, you may proceed. It's just a curiosity.
Oh, thank you, Your Honor. Continuing, as the opposing counsel has said that the payment of the fine by the state of Asturias is an admission of guilt, I may say that actually the payment of this fine was not a recognition of any wrongfulness, but it was only an attempt to ease the tensions with its long-term friend and fellow SIDS. Passing forward, my opposing counsel has said that the principle of Estoppel would issue that Asturias has made a contradiction by paying the fine and lately saying that there was no wrongfulness, but as it was only for the ease of the tensions, there is no contradiction in the Asturian position.
I'm sorry, there's a problem in the audio. Perhaps if the respondent one could close the audio, if it's possible.
We are sorry for this issue.
No problem at all.
If I may proceed. Regarding the state of necessity, my opposing counsel has said that there was no essential interest being protected in front of a grave and imminent danger by the part of Asturias. He failed to consider that the main reason which triggers the necessity condition for Asturias is not only climate change. We, as the Asturian councils, admit that climate change was a reason that exacerbated the situation although it was the Curious 16 virus that is the main reason which triggers necessity. And as the UN General Assembly and many other international organizations had recognized, that year was the year of hunger. That year, various countries had suffered grave danger, grave and unforeseen danger, as there was no possible predictability of such an event happening. So the opposing counsel has used the case Gabsikovo-Najimaro to say that the standard of proof required was above the
Excuse me,
meant.
counsel, to interrupt you.
Please, Your Honor.
You are mentioning the General Assembly. In what is the purpose of you by mentioning this? Because as you know, resolutions or whatever decision is taken by the General Assembly, is it a part of international law? Is it something that can be taken into consideration by this tribunal to take a decision? What is the value of the General Assembly intervention? Thank you very much.
President Cabello, Your Honor, I thank you for your question. And I may say that I mentioned this UN General Assembly position because my opposing counsel has issued that there was no proof by the part of Asturias that they were facing a grave danger. And as the General Assembly, although it does not bind this tribunal by any means to take in any decision, the UN General Assembly is a respected organ which had declared that such a grave danger was in order. And I may also highlight your intervention, Your Honor, in my opposing counsel's exposition regarding that the needs of the respondent in front of the pandemic, facing a pandemic, must be regarded in the present case. If I may continue.
Just to clarify, you are attributing no legal value to the General Assembly resolution. Is that correct?
Mr. Judge Lima, Your Honor, I am not attributing any legal value as it is a source of international law, a subsidiary source. But for this case, I am attributing it for an interpretation matter to lead the correct interpretation of the fact into its rightful interpretation.
Has this tribunal ever used a resolution of an international organization to interpret any source that this tribunal has supplied?
Yeah, and in the moment, I do not recall.
Thank you very much. You may proceed.
Thank you, Your Honor. And proceeding, as proved that there were a grave and imminent danger in front of Asturias because of the Curious 16 virus, it was said also that the actions had impaired the essential interest of other states, and it did not regarding the circumstances of the present case. It is construed indeed by the International Court of Justice that the ecological balance is an essential interest of all the states, but this ecological balance was not impaired, in fact, by the Asturian conduct, as the fisheries were only artisanal and did not have any major harm for the marine biodiversity and the fishing stocks within Calypsus EEZ. The situation brought by the opposing counsels of the Gabsikovo-Najimaros are really different from the present case, in which in Gabsikovo-Najimaros there was no virus, there was no unforeseen event that could be put in order to if I have a minute.
But there were environmental concerns, Consul.
Indeed, there were environmental concerns, but in that case, it was being discussed the construction of an extremely harmful dam in which the essential interest of the ecological balance would be necessarily be impaired by other means such as the pollution from the dam. In this case, it was just artisanal fishing conducted by small vessels in Asturias. Therefore, there was no impairing essentially of the ecological balance on the applicant's EEZ, And fourth, and the most intriguingly, it says that the state of Asturias contributed to its own situation of necessity. Again, assuming that climate change was the main reason which triggered a state of necessity, which was not, it was the virus. And by no means it can be said that the situation of necessity, the virus, was by any means exacerbated or substantially a contribution of Asturias, a small island developing state, as the main reason which triggers the necessity is the virus. It's also been said that the Asturian country has failed to adopt a precautionary approach in its marine protector and its marine biodiversity. And if I may quote the case files, precisely in its paragraph 4, and I may quote, "The current president in place since 1998 supported new long-term marine restoration policies to secure the economic, social, and environmental development of the country." By the reference to the case files, it can be seen that Asturias had done everything in its reach to adopt a precautionary approach in order to safeguard its marine biodiversity and its fishing stocks. But mostly, it cannot be held responsible for its food crisis, as the food crisis were not made primarily by the fishing stocks relocation due to climate change. They were due to the virus, which had impaired the Asturian possibility of providing food to its inhabitants, as 60% of the food in Asturias was imported, and the international trade was complete. Yes, Your Honor.
Could you give this tribunal a very succinct definition of precautionary approach? Because the applicants mentioned the precautionary principle, and you are mentioning the precautionary approach.
The precautionary approach, which I meant, is a reference to the Asturian actions in order to safeguard to plan well ahead and to safeguard its marine biodiversity and fishing stocks.
Has this tribunal ever applied the precautionary approach or principle?
Mr. President, I do not recall at the time.
Thank you very much.
Thank you. And just continuing by saying Asturias is responsible to its own food crisis, one may essentially misunderstand the reason which led to such food crisis, which was a virus completely unforeseen, and 60% of the Asturian food is imported. By passing forward in this phase of the refutations to my opposing counsel's main arguments, if this tribunal finds that by any event the respondent violated its obligation to ensure that vessels flying its flag do not conduct IUU fishing in a third state's EEZ, the following must be observed. Ordinary norms cannot be applied to extraordinary circumstances, and the international law is no stranger to that kind of situations. In the present case, not only one circumstance precluding wrongfulness can be invoked, they are both the state of necessity and force majeure that may equal the balance in favor of Asturias. The rules and principles governing these circumstances are generally recognized as the ILC Articles on State Responsibility, applicable to this case via Article 293, and written down in the ILC Articles on State Responsibility hereinafter mentioned as the RCWA. The state of necessity is caused, I quote, by a clearly grave and imminent danger to an essential interest, and stop the quote, and the allegedly unlawful act must be the only way for the state to safeguard such essential interest. Interestingly, under this defense, the state facing a state of necessity may take voluntarily an action that a priori is unlawful, but has its wrongfulness.
Excuse me, counsel.
Yes, Honor, please.
You are mentioning the state of necessity. In many occasions, you mention it. Where in the convention, the state of necessity is mentioned as an exception, or could be considered as an exception, not to comply with the main rule, which is to have due regard of the coastal state laws and the sovereign right the coastal state has on the resources in his economic zone.
Your Honor, Mr. President, I thank you for your question. And to answer it, I believe that the reference I am making is not directly in the UN Convention on the Law of the Sea, but it's in the IOC articles on state responsibility that are considered by this court in its 2015 advisory opinion and others as customary international law and therefore applicable to this case via Article 292 of the present convention. If I may proceed.
Court, I'm sorry for interrupting you, but I would like to construe upon the President's question. This court has considered the whole of the articles as corresponding to customary international law?
If I may take only one moment.
Let me question directly. This court has considered the circumstances precluding wrongfulness as corresponding to customary international law? You have 2 minutes just to tell you.
Mr. President, I'm sorry, Mr. Judge Lima, to a large extent, the IOC articles on state responsibility have been used by this court as customary international law. And some cases, such as the case which I referenced in the 2015 advisory opinion on IUU fishing, these IOC articles are admissible as customary international law, if that answers your question.
Okay, yes. Perhaps you could construe upon the argument of force majeure.
Thank you. Constructing in the argument of force majeure, firstly, Your Honor, if I may continue the argument in which I attribute the actions of the nationals of Azorius to the state in order to invoke state of necessity.
You have 1 minute, counsel.
Perfect, Mr. President. So I will use the following time to address the force majeure argument. The force majeure defense should be accepted if by any reason state of necessity is not recognized by the present court. I quote that in the RCUA, accordingly, the wrongfulness of an act precluded by the force majeure, not in conformity with an international obligation of that state, is precluded if the act is due to force majeure, that is the occurrence of an irresistible force or of an unforeseen event, beyond the control of the state, making it materially impossible in the circumstances to perform the obligation. In the present case, there are clearly irresistible forces, such as the worldwide health and economic crisis, food shortage, and climate change. If by any case the respondent do not comply with its due diligence obligation, it is certainly due to these irresistible forces, clearly beyond the control of a nearly 33,000 people country, making it materially
is over, counsel.
Impossible. Thank you. That was the speech for the respondent.
If I may now, I would like to give them the opportunity to both parties to use the minutes remaining for whatever extra explanation you want to have. I think you requested some time for that. So I provide you with this opportunity. So please, I invite then the applicants, the councils, to take that opportunity. Please, first applicant, first counsel. The
I'm sorry,
applicant.
Your Excellency. So this
Who is
is
going to talk? You. Okay.
this is the
You have the
rebuttal.
floor.
This is the rebuttal. Just a clarification. Okay. Thank you, Your Excellency. In the next 4 minutes, the applicant would like to submit 2 points of rebuttals on jurisdiction and merits. Your Excellency, With all due respect, the applicant would like the tribunal to highlight numerous subsidiary international law sources which shall only be used if the primary sources have already been established. The respondent argument are based on dissenting judge opinion, scholar, which they define as renowned publicist, without clear definition. Your Excellency, expert or jurist can only be a source of international law as a last resort, but it seems that the respondent used this to strengthen their main case in regards to the jurisdiction. On the second point, the respondent in this case made a significant claim that this tribunal has no jurisdiction over the case. The applicant response is simple: pacta sunt servanda. An agreement is a law that binds both parties. 5 response to this. Firstly, application on the doctrine of Estoppel, as already mentioned in the court, shall dismiss the contradictory claims on the basis of representation. In this case, the respondent signed a BFA, which is governing law between parties setting out rules, rights, and duties, which are reflected to the UNCLOS. The BFA are made because the UNCLOS was ratified by both parties. But second, under Article 3 of the bilateral fishing agreement are made in accordance to the relevant international laws, which in this case is the UNCLOS and other relevant customary international law. But thirdly, even explicitly under Article 32, it is stated regarding the choice of forum, which any dispute on arising from this agreement will be based on the procedure of the UNCLOS, as well as settled before the ITLOS. Furthermore, Article 287, paragraph 4 of the UNCLOS, it is clearly stated if the parties to a dispute have accepted the same procedure for the settlement of the dispute, it may be submitted only to that procedure unless the parties otherwise disagree.
Counsel, you said that they have only weak sources to base their claims, but you also invoked decisions of international tribunals, which are also subsidiary. How to respond to that?
Your Excellency, if the applicant may beg to differ, the applicant invoke those kinds of subsidiary at least to establish the merits and the arguments of the case. But the respondent here brought the subsidiary international law as the first claim in this tribunal to dismiss the dismiss and reject the jurisdiction of this tribunal. Fourthly, the fact that the respondent did agree upon this at this point in front of the tribunal, reject it again, means they are contradictory, and the tribunal shall stop the respondent. Lastly, Your Excellency, the fact that the respondent keeps violating estoppel and going back on its word and obligation shows an intention of bad faith to settle this stellar dispute. The reason why this tribunal has jurisdiction of the case are already explained by my first counsel. Firstly, peaceful means have been established, which was 8 meetings. Secondly, exchange views have also been established during the video conference. And lastly, the choice of forums are clear within the 1996 bilateral fishing agreement, which put ITLOS as the solely choice of forum to settle this case. The applicant believes that the respondent hasn't responded to all of these 3 submissions in their cases. Your Excellency, when the respondent firstly came to this tribunal and declared at a bad faith by stating that the tribunal did not have any jurisdiction to settle this matter, but at the end, the respondent still argued about the merits of the case, such as flag state duties, due diligence, and insufficient proof. Thus, the applicant believed that we do not need to provide a rebuttal to the respondent concerning the merits of the case, as they are being misleading and confused in applying the law. But even if the respondent argument concerning the merits of the case can still be considered, the applicant believes that the applicant previously has been establishing a sufficient standing on flag state, unfulfilled due diligence, insufficiency of the state of necessity, and even the respondent mentioned force majeure at the last minutes of their speech, which are very distinct from the one that they submit, which is the...
Your 4 minutes are over. Perhaps you could finish your phrase.
Your Excellency, thank you. On behalf of the applicant, it has been honored to appear before Your Excellency President Cabello, Judge Lima, Judge Kelly, and the respective ITLOS. The applicant demands the tribunal to assess this case fairly and dismiss the claim of objection of jurisdiction by the respondent. Thank you. The applicant rests their case. May it please the court.
Thank you very much. Is there a request also for rebuttal from the respondent side?
Yes, Your Honor, President Cabello, there is.
Yes, you have the floor then.
Thank you, President. In 2006, the President of ITLOS at the time, Rudiger Wolfram, and the President of the ICJ at the time, Rosalind Higgins, both have said with clarity that they take the necessary considerations to further the unity of international law. In spite of the proliferation of international tribunals, they want unity in international law. This is very appreciated by this tribunal, and this tribunal seeks for unity in international law. Also, it seeks to have respectable decisions. These respected decisions must be, firstly, of course, to the renowned publicists that will later criticize or louder and compliment this tribunal's decision. So these opinions, both in precedents and from renowned publicists, should be taken into consideration by this tribunal. Finally, I'd like to thank you for the opportunity delivered and apologize for our extensions within our time. I appreciate and good evening.
Since we still have time, may I ask you a question? You are saying that we have to take into account the scholars that comment the work of this tribunal. Aren't the states the main clients of this tribunal? And shouldn't we pay attention to the practice of states and what states do and in the practice of international law?
Yes, indeed, Your Honor. You should pay attention, of course, as you mentioned, to the practice and the opinion of states. But those of relevant publicists are quite relevant. And in your deliberations, I'm positive that you take into consideration them.
Thank you, Counsel.
I'm done.
Well,
Thank you.
I think that this, okay. This concludes then the final round, if I'm not wrong. And I will invite then my colleague judges to meet now to take a decision on this case. Thank you very much to all of you. You have been very responsive, and I congratulate you for the way you have been defending your positions. Okay, see you soon.
Okay, so teams should leave now, if they haven't left already. And then come back to the same link. Okay, so we should wait a bit before we get Okay, so we're back live on YouTube. Thank you for waiting. Without further ado, I'll give the floor to Mr. President Judge Cabello for the results and feedback.
Thank you. Dear councils, if I say that we have a long debate, I will be lying. You know perfectly that we have this constraint of time, so we couldn't discuss for as much of the time as we would have liked it. Anyway, it was very active, an active discussion. We have the three judges. And really, I would like to congratulate all of you. You put really an effort. It's clear that you study the case and you study also all the necessary resources were used, for the preparation of your positions. Anyway, we have to give a decision. There has to be a winner. So we all agree that the best presentation was made by the applicants. And in particular, I would like to praise the fact that they have a good management of the work. You manage your time properly. And of course, the sources that you mentioned were appropriate. But also we have some doubts because also on the side of the respondents, we realized that your position was weaker. If you read the documents, in a way, the main document, the presentation of the case, it is clear that it is more favorable for the applicant maybe than for the respondents. But we have to take a decision, and of course, we agree all that the applicants were doing better. I would like now to invite my colleagues, Judge Kelly first, and then Professor Lima, Judge Lima, to give their opinions. Please, Judge Kelly.
Yes. Well, I very much agree with what you just said, Mr. President. In trying to evaluate the performance of each of the participants in this exercise, I would say that the applicants had a better presentation, perhaps based that their case was a stronger case vis-a-vis the respondents and had a very difficult case to defend, So from that point of view, of course, I must agree with you that the applicants had a better performance. Without diminishing the performance of the respondents either, because as I say, the case they had to defend had many pitfalls and difficulties. So it was not an easy exercise for them to do. But having said that, I think that there's nothing much more I can say. Thank you.
Guys, please, before anything, don't hate me. The organization asked me to be tough on you. All the organizers sent me messages this afternoon saying you have to be tough. This is the final. And look where you guys are right now. You are in front of two ITLOS judges arguing, making them, evaluating your positions. So you went splendid. And I think that you both teams can be proud tonight because you did a beautiful work. And I think that the fact that you have an annoying judge asking you questions all the time. Judge Kelly in the beginning said to me, I would hate if anyone would interrupt me
Right.
when I was speaking. And I said, okay, they will hate me because I will have to interrupt. But these interruptions are the opportunity to evaluate you, to see how much do you know about the law of the sea, how much do you know about the case law, and how you argue. And I think that's very nice that you can construct all this, even the weaker argument. We know that the respondent had less arguments, but even there you have the opportunity to show the abilities, and you did that. And I think that you could be very proud tonight. I think that it's your first time that you participate, both teams, the competition. So be very proud of your work. I am very proud to be here with you. I'm very honored to be here between these two giants of international law and international law of the sea, Latin American lawyers that are very important and achieve very much for our continent. So I am very proud to be here. I thank you again, the organizers, for inviting me for this opportunity. I learned a lot, and I congratulate you because you did very well and you can sleep proudly this evening. Thank you, President Sarubi, for giving me the opportunity to share these words.
Well, I think with these words, we put an end to this session. Congratulations to all of you. Really, you will be the future judges. One of you, I'm sure, will be there one day. You are well prepared, and especially you have the spirit, the interest, the vocation for this. I can see that from your interventions. Congratulations then again. Thank you very much.
Okay, so would any of the judges like to make any further remarks, or is this the end of the feedback session?
I would just say, don't miss Judge Sarubi and Judge Kelly's conferences during the conference, because it's usually very, very good to hear. So do not miss it.
Thank you. Thank you, Judge Lima, for the intervention.
Thank you very much.
So if this is all, then I would like to congratulate both teams. Congratulations, applicants for winning as well. And it was really, really an interesting competition overall to see how the teams developed and how they started, arguing more clearly and more concisely and being more sure of themselves, because I've been watching the rounds since round 1. So it's been a really big evolution for everyone. And I'm sure this has added some really good experience for you. And well, thank you to our judges. It's been a fantastic evening to have 2 ITLOS judges judging our moot. I'm sure that our participants have learned a lot from you and from your interventions. So thank you so much again for volunteering your time to be here and to share your expertise with our mooters. It's been an amazing evening. And thank you, Judge Lima, as well, for being the quotation marks annoying judge. I'm sure this has contributed for the development quite a lot. And well, I think this is the end of our final round. So congratulations to everyone. And thank you for attending the moot.
Thank you. I want to thank the organizers also for having invited me to this exercise, which is very new for me. And I have learned very much from all of you. Thank you. And congratulations to the participants and to the winners also. Congratulations.
Thank you, Judge Kelly. So
thank you, Julia. Thank you for your support, Julia. Thank you very much.
You're very welcome, Judge Cabello. Thank you for your participation. So this is the end of the session. So
we leave the room now? Should we leave?
You may leave the room. Yes, everybody can leave the room. Thank you very much for
Bye,
everything.
Lucas. Thank you.
Ciao, ciao.
Thank you.
Ciao.
Thank
Goodbye.
Bye.
you.
Awesome.
Future love.